Hey there! My name is Lindsay, and I'm a legal researcher with Lawsuit Legal. Today we're going to be discussing the Family Medical Leave Act and the employer obligations that it entails. The Family Medical Leave Act was passed in 1993 as a federal law that requires employers to provide employees with job-protected and unpaid leave for qualified medical and family reasons, including personal or family illness, family military leave, adoption, and pregnancy. The FMLA was intended to balance the demands of the workplace with the needs of the families, according to the Department of Labor. The Family and Medical Leave Act is administered by the Wage and Hour Division of the United States Department of Labor. To be eligible for coverage under the Family and Medical Leave Act, an employee must have worked for that employer for at least 12 months, have worked at least 1,250 hours during the 12-month period, and work at a location with at least 50 employees that must be within 75 miles of their workplace. The FMLA creates 4 options to calculate a 12-month period. The 365-day 12-month calendar year starting January 1st through December 31st, a fixed leave year in which an employer may select any fixed 12-month period, such as a fiscal year or an employee's employment anniversary date, a 12-month period beginning with the date that an employee's first FMLA leave begins, and a 12-month period that goes backward from the date an employee's first FMLA leave begins. Your company is covered by the Family Medical and Leave Act if it has employed 50 or more employees for 20 or more weeks in the current or preceding year. An employee is eligible for leave under the FMLA if they are either a full-time employee, a part-time employee, employees who are on leave and are expected to return to work, and employees who work jointly for the company and another company. There are 3 different kinds of leave under the FMLA. Continuous FMLA leave, in which an employee is absent for more than 3 consecutive business days and has been treated by a doctor. Intermittent FMLA leave, in which an employee is taking time off in separate blocks, either in hourly, daily, or weekly increments. And reduced schedule FMLA leave, in which an employee needs to reduce the amount of hours they work per day or per week. The qualified medical and family causes for leave under the FMLA include personal or family illness, family military leave, pregnancy and birth, caring for a seriously ill child, spouse, or parent, and the adoption or the first care placement of a child. Under the FMLA, a serious health condition must fall into one of the following 6 categories: inpatient care, incapacity for more than 3 days with continuing treatment by a health care provider, incapacity relating to pregnancy or parental care, chronic serious health conditions, permanent or long-term incapacity, and certain conditions requiring multiple treatments. New parents, both mothers and fathers, can take FMLA leave anytime in the first 12 months after childbirth, and the FMLA rights extend to all spouses, including those in same-sex marriages. In the case that both parents of a newborn work for the same company, they are entitled to a combined total of 12 weeks leave after the birth or adoption. There are a number of reasons for parents to take parental leave, including prenatal care and incapacity related to pregnancy or the afterbirth of a child due to the employee's health condition. In 2008 and 2010, the Federal Medical and Leave Act was amended by the NDAA, National Defense Authorization Act. The NDAA expanded the reach of the FMLA by granting leave under certain circumstances to employees with family members in the military. A qualifying family member may take up to 12 weeks of FMLA leave if the employee has a spouse, parents, or child who is a military member on covered active duty, been called to cover active duty status, or has been notified of an impending call or ordered to covered active duty. An employee may take qualifying exigency family leave to spend time with a family member prior to a short notice deployment, to attend military events and related activities, to arrange for child care and attend school activities, to help handle financial and legal arrangements, to attend counseling, to spend time with the family member on rest and recuperation leave, and to handle certain post-deployment activities. The FMLA also gives leave time to employees who are the spouse, parent, child, or next of kin of a service member who suffered a serious injury or illness incurred in the line of duty or active duty in the armed forces. This leave can be up to 26 weeks in a 12-month period to care for the service member and can be used in combination with regular FMLA leave. The Family and Medical Leave Act allows states the option to set their own standards when it comes to the family and medical leave laws, which could sometimes be more expansive than the federal law. For example, the federal FMLA only applies to employers with 50 or more employees within 75 miles. Some states have enacted their own FMLAs that have a lower threshold for employer coverage, including Maine with 15 or more employees for private employers, and 25 or more for city or town employers, Vermont with 10 or more employees for parental leave and 15 or more employees for family and medical leave, and Washington, D.C., which is 20 or more employees. Some states also expanded on the definition of what is considered family, including California, which includes domestic partners and their children, Connecticut, which includes a civil union partner and parent-in-law, and New Jersey, which includes a civil union partner and their children, parent-in-law, and step-parents. 4 states have also passed laws which require paid family and medical leave: California, New Jersey, Rhode Island, and New York. If you feel like your employer has violated your rights set forth in the Family Medical Leave Act, you may be entitled to compensation, including back pay for lost wages, salary, and employment benefits, front pay, which is compensation in the future due to the violation, reinstatement, compelled hiring, or a promotion, compensatory and punitive damages, and reimbursement of attorney's fees and court fees. The most common reasons for employees to file FMLA complaints include wrongful termination or job loss by those who requested FMLA leave, employers' refusal to grant rightful leave, employers' refusal to restore employee to equivalent position after returning to work, and employers' failure to maintain health benefits while on FMLA leave. If you feel like your FMLA rights have been violated, you should seek out legal representation to further discuss your issues. Lawsuit Legal helps connect people to qualified lawsuit attorneys who will make sure you are aware of your legal protections and ensure your voice and needs are not ignored. Lawsuit Legal makes it simple and easy to acquire award-winning legal assistance when it's needed most.